So chapter 20, transfer of title. In this chapter, we're going to talk about the 4 methods of title transfer, explain the process of the transfer of title of a deceased person's property, and some other death terms and whatnot. So the word title simply means ownership. There's no document in real estate called title. Alienation is the transfer of land, or in this case, since we're talking about ownership, the transfer of ownership of that land. And this can be done during somebody's lifetime or upon their death. It can be done voluntarily or involuntarily. At death, it's done voluntarily through your last will and testament. Or if you died without a will, involuntarily. It's done involuntarily because you don't get to determine who gets your stuff if you die without a will.
Mm-hmm.
The state will determine that. And if they can't, they keep your stuff. So title to the real estate means the right to or ownership of the land. That's on page 371. So let's go to page 371. Chapter 20. And let's highlight title to real estate means the right to or ownership of the land, and alienation is the transfer of title to a parcel of real estate.
Okie dokie.
Mm-hmm.
Turn the page, and voluntary alienation of can be done by gift, sale, or exchange. You could sell the property, give it away, or exchange it. And owners use some form of deed to convey that ownership during their lifetime while they're alive to sell the property or transfer the ownership. Or they transfer that ownership by a will upon their death. So how do you transfer ownership of real estate after you die? Through your will.
Through your will.
While you're alive, ownership is transferred by deed. If you signed a deed transferring your ownership of real estate, when does the transfer of ownership take place? Upon delivery and acceptance of the deed itself. If you sign the deed and you name somebody as the buyer of that property, but you never actually delivered the deed, did the transfer of ownership take place? No.
No.
So therefore, the transfer of ownership would not go according to the deed if you never delivered it. It would now go according to your will.
To your will.
So transfer of ownership to or from the government is done by dedication. Dedication, you could give land to the government for a public use like streets, schools, and parks. And often when somebody is, say I have a large lot and I'm going to subdivide it and I'm going to put a cul-de-sac street on it and I'm going to build 6 or 7 houses on that cul-de-sac street. That street was actually paved and built on my land. So am I going to be responsible for maintaining that street and keeping that street? Or can I give it to the government and it'll become a city street? I can. It's called dedication. I'm going to dedicate that land, that portion that's the street, to the city. Now it becomes their property and they need to maintain it. So, I mean, I'm subdividing my land, building houses, and I'm selling all the houses. Why would I need to keep the street to maintain that? What a burden. And, so I'm just going to dedicate it to the city so that they could, it's now their property. If the city were to give me property or sell me property, it would be done by public grant. When the government gives land to a private individual, it's through grant, a public grant, because it's publicly owned property. So let's highlight this stuff now. Voluntary alienation, involuntary alienation. When a person dies and leaves no heirs, the title to their real estate passes to the state through the process known as escheat. And if you have a co-owner that you own land with, and you no longer want to own that property, you could go to your co-owner, that your partner, and you could ask them to buy you out. But if they don't have the money to buy you out or don't want to buy you out, are you stuck owning that property with them? No. You could try to sell your ownership and get your own buyer to sell your ownership interest, and then that person who you sell it to will become a co-owner with your current partner. That may be difficult to do, finding a buyer who's willing to buy into a property with somebody they don't know. Usually when people buy properties, they want to own it outright. So that's very difficult to do usually. So you may have trouble doing that. So now what? Are you stuck owning that property? You can't get out of it? No. You could sue your co-owner, your partner. You could take them to court in what's known as a partition proceeding. A judge will look at the property, examine it, and see if it could be physically partitioned. But if that's not possible, then they will order a sale of the property. And then each of the owners will get their proportionate shares of the proceeds from that sale. So the first thing they'll do is they'll see if that property can be physically partitioned and turned into two separately deeded properties. And if that's not possible, then they'll order the property sold, and each person will get their money, their interest in that property. Okay. So you're not stuck owning it with them, but you would have to sue your co-owner, if they can't buy you out or don't want to, and you can't find your own buyer. That's the last option you got. Let me know when I can change the slide.
I'm good.
I'm good also.
So that's involuntary alienation. Is a transfer without the owner's consent. This can be done by escheat, through eminent domain, through foreclosure due to unpaid debts like taxes or mortgage loans, through a court action in a partition proceeding. You don't want to sell the property. You're being forced by your partner co-owner to sell the property. Through adverse possession, when you have an adverse possessor that's squatting on your property and trying to claim ownership of it. Or through erosion by Mother Nature. She could decrease the land that you have by wearing it away. That's a form of involuntary alienation by Mother Nature. So let's talk about that adverse possession for a moment. An easement by prescription is also known as squatter's rights or adverse possession. Somebody who's adversely possessing your property, adverse to your ownership, your title. If they're using your land out in the open for a long enough period of time as defined by law, they could actually claim ownership of your land. So when you use someone else's property for a period of time as defined by law, you could claim ownership of that land that's being used. However, just because you've been using someone's property for a period of time does not automatically make you the owner of it. You have to take them to court and sue them and prove that you've been using it. So to perfect this easement by prescription, it requires a court action called a suit for adverse possession, also known as a suit to quiet title, to claim the ownership of the land. Now, the use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Without the owner's approval. Additionally, the use has to be visible, open, and notorious. It can't be like you're sneaking on the property and using it for years and they never knew about it. It has to be blatantly obvious. You're out in the open using their property. The owner's huffing and puffing and bitching and complaining, but not doing anything to get you removed from the property. If you're there for a long enough period of time as defined by state law, you could sue that owner through a suit for adverse possession to claim that ownership. Now, in New Jersey, the prescriptive period is 30 years for improved land and 60 years for unimproved to claim ownership. However, this will change at some point in the future. It's going to change to 20 years, which is the common law period. Right now, the New Jersey politicians created too many laws covering the same topic. And each one of them have a separate amount of time that you have to use the land for before you can claim easement by prescription. Because of that, there's no way for a judge to determine how long of a time you need to be using it for. So there was actually a case, it was a long time ago already. This is well over 10 years ago, 12, maybe 13 years ago already, as long as I've been following it, that I've been aware of. There was a company that sued another company because they've been using their land. They put a fence around it and they've been using it for so many years. So they filed an adverse possession claim to take ownership of the property. However, the landowner argued that, well, because you had the fence up there for 60 years because it was unimproved lands, you still can't claim ownership because according to the other laws on the book, you had to make that claim after 20 years, but you didn't do it. And they said their argument was, yeah, because for unimproved lands, there's a law in the books in New Jersey that says you got to use it for 60. And he says, yeah, but there's another law that says you had to claim it after 20. So because of that, there's conflicting rules, and a judge did the rightful thing. Judges are not supposed to rule and make decisions and create law. They're just supposed to interpret the law and render decisions based on the law that politicians created. But in this case, politicians created too many laws covering the same topic. So it's impossible for them to rule one way or another. So the judge actually did the right thing in this case. They kicked the court case out and kicked it back to the politicians to fix the conflict in the law. And then they could render a decision once the politicians decide what they want the law to be. See, sometimes you get judges that do the wrong thing. We call this legislating from the bench. They basically create a law by ruling and making a decision themselves on something where the law did not specify something. And when judges do this, they're actually creating a precedent that all future court cases are going to use as the rule from now on, even though no actual law was written or created by politicians. That's the way laws are supposed to be created. Politicians create the laws, judges interpret the law and make rulings based on the law. So this judge kicked it out of court and did the right thing. See, this could create all kinds of problems when judges don't. Just take a look at last year. We had that case of Roe versus Wade pertaining to abortions, right? In the, what was it, in the 70s or something, they passed this. Well, there was never a law passed that made abortion illegal in the United States. There was one single judge that ruled on a case where there was no law written. And you had a lady that stepped forward and she made a claim that she needed to be able to do an abortion in order to, for medical reasons, it was necessary for her to have an abortion and . So a judge made a ruling on it and allowed her to do it and therefore created a precedent. And this was the lawsuit of Roe versus Wade that now created a precedent for the which all future decisions were based on. And so you had people out there that were saying, oh, there's a law now that says abortion's illegal. No, there is no law. There was one judge, one man made a decision which created a precedent that followed for the next 50 years. So the argument of what happened, somebody actually argued it and brought it up to the Supreme Court 50 years later, right now, and actually made the argument. And the Supreme Court actually threw that judge's decision out of court because they said he improperly rendered a decision that was not based on any law. He basically legislated from the bench and created a de facto law. And that's not the way laws are made. So the Supreme Court just threw out that judge's decision. They didn't undo the law because there was no law. They just said, we're going to undo this judge's wrongful decision, and we're going to put it in the hands of each state to create their own law, because our politicians in Senate and Congress did not pass a law. So we're going to leave it up to each state. Unless the politicians in Congress pass a law, we're going to leave it to each state to determine what law it is that they want on this topic. And they could create their own laws. That's all. That's the only thing that happened last year. See, people are all in uproar over this, and you see how crazy the country got over it in the news and everything. This is what happens when judges do things that they're not supposed to, because that's not the way our system is set up. Now, in New Jersey, our politicians created too many laws covering the same topic pertaining to adverse possession. So a judge did the right thing and he threw the case out of court. And then he said, politicians need to clear this up. Now, as long as I've been following this has got to be going on 14, 15 years now. The New Jersey politicians know what they want to do. They're going to get rid of this 30-year period and 60-year period, and they're just going to go with the common law 20 years. And they're all in agreement that they want to do it. 14, 15 years later, they still haven't. What are we paying them for? You know, I just laid out a good case. How come people are not pressing politicians for, I mean, they can't do simple stuff. But you know what? If they want to pass a new tax because they want more of your money, how long did it take them to create that new gas tax? What was it, like a year or two ago? They created a new gas tax in New Jersey. What did it take them? 30 days? 30 days to create, legislate, and pass a new law in 30 days to create a new tax to get more of your money.
Yep.
But to fix a problem like this that's on the books that they already know the answer to and what they want to do, 15 years later, you're still trying to get it done.
I'm done. Figure it out.
I don't know. I can't explain it. But they're passing laws so that criminals, you can't do background checks on ex-convicts to determine if you want to rent your property to them or not, because that makes you a criminal, because now you are discriminating against people because the criminal justice system is racist. We went over that in chapter 4. You watch the recording of it. I recorded that whole thing. Now, what do you need to know for exams here? Well, what is the prescriptive period to claim ownership of somebody's land when you've been using it against the owner's permission? Well, it's 30 years for improved lands and 60 years for unimproved. That's what you need to know for exams.
Okay.
Now, just be aware sometime in the future that's going to change, but it has not changed yet. Even the book manufacturers thought it was going to change so many times. You could see the wording in this book seems kind of confusing when they talk about this topic, because it's listed in 2 areas. One area it says the law has not been clear, the law is not specified. In another area, it talks about the years. In previous versions of the book, they dropped this 30 and 60, and they were mentioning only the 20-year period, when that wasn't the case, because they did not cure it yet. They did not fix the problem yet. And then the previous version of the book before that, it said 30 years and 60 years, but they're going to change it to 20. So like you could see, like even the book manufacturer thought that they already cured it up by now, but they still haven't. Yeah, that's our politicians here in New Jersey.
Mm-hmm.
Now, does one person have to occupy the land this whole time? Well, let's see. The use must be continuous, hostile, adverse to the owner's title, exclusive. However, through the process of tacking, Successors in interest can add one person's time of possession to that of another, combining them to reach the prescriptive period. Now, they had to have been successors in interest. And what is a successor in interest? We're going to highlight in a moment. That's like an ancestor and an heir, a landlord and a tenant, but we'll see in just a moment. Now, how could you prevent somebody from claiming ownership of your property by easement by prescription? Well, you could take legal action against any adverse possessors to get them removed from your property. You could cut off their access. This stops the continuous use time clock and resets it. Or you could give them permission to use your land. You can't claim ownership on somebody's property by an easement by prescription if you gave them permission to use your land. It has to be hostile, adverse to the owner's title, exclusive, and without the owner's approval. So if you gave them permission, that resets the time clock. It stops it right there. They cannot move forward. And you cannot claim an easement by prescription against publicly owned land.
Okay.
All right, so let's do some highlights here. This is on page 373 under adverse possession. I wrote easement by prescription and alienation here. And in chapter 6, we're going to go over this on page 110 and 111. So that's just a little cross-reference there. That's what that says. And then the time limits here, 30 years for improved lands or 60 years if woodlands, basically unimproved lands. The term tacking means that you could add continuous periods of adverse possession by successive users, enabling a person who's not been in possession for the entire 30 years to establish a claim of easement by adverse possession. But this process is not automatic. Legal action is necessary in order to perfect that claim. It's called a suit for adverse possession or a suit to quiet title. So to prevent somebody from ever making such a claim, a property owner should walk the boundaries of their land at least once every 30 years, and then take action against any adverse possessors to get them removed from your property. I mean, if you don't walk your property's boundaries every 30 years, at least once every 30 years, come on. That's reasonable, right? To walk your own land at least once every 30 years. Instead of just sitting on ownership of property, you should actually be using the land that you own. Somebody can claim that ownership. Now, this last thing is really interesting, but it's not on exam. But I found this helpful in my real life here and using this. Property owners basically that feel new government requirements have taken away their rights to use and develop the property that they own, because they put so much red tape in place through zoning ordinances and building restrictions and all kinds of stuff like that. If your politicians in your town created so many laws that made it next to impossible to use your own land that you own, rendering it useless, this is known as inverse condemnation. They're basically condemning your property, not straight out, but by creating all kinds of use regulations and red tape that you can't use your own land. They render it useless. They basically devalued your property. a landowner can sue the government, forcing them to pay them for the value that they lost on their land through all the red tape and government regulations that they put in place. I recently talked to the mayor of a town about this. I gave them a little advice on this because they were wanting to move forward on a property owner to try to force them to do something or not to do something, some improvements she wanted to do to a lot of land she owns and buildings she owns, which could make her a boatload more of money. And but they like the quaintness of the town and the old world feel and such. So I warned them that the town can get sued for inverse condemnation, and they would have to pay her a lot of money if she goes that route. So you better be careful how you approach this. So they started consulting with their attorneys, and they were like, "Yeah, he's right. You know, we gotta tread lightly here. On we want to maintain the feel of the town and the old world feel of the structures here and everything and the commercial area, but she may want to tear them down and put up these luxury housing and high rises and all kinds of other stuff, and that's her right. It's her property, but we don't want that because most of the town's already being built up like that. Well, then how come you didn't enforce those regulations and you passed the permits to build those things elsewhere in town, but now you want to force her? You better tread lightly because you're basically taking value away from her. All right, so the burden is on the owners who must prove the government's action that has taken the property rights without compensation, and then she could get the money from the town for that. Now, this is in chapter 6. You don't have to go to chapter 6 now and make these highlights, but these are the highlights and notes that we're going to make in chapter 6 on page 110 and 111, also about the easement by prescription. That's where the wording is a little bit different there on that slide. Okay, so we'll get to this when we do chapter 6. So I got these slides in chapter 6 as well. So how do we transfer a deceased person's property? Well, we do so by last will and testament. That's the document used to transfer the ownership after their death. So the transfer of title by will is known as devise. And if you had made a will, it said that you died testate. And if you did not have a will dictating how your assets were to be distributed, you died intestate, right? Because testate means you prepared a will stating how to dispose of your assets. And a will has no power until after you die. Up until the point you die, how does ownership transferred? By a deed.
By deed.
A deed is the document used to transfer your ownership while you're alive. A will transfers the ownership after you die. And if you die without a will, you died intestate. And the transfer of your property to whoever gets it is involuntary because you didn't decide who gets it. Only your natural heirs can step forward and claim it, or the state will get it.
Mm-hmm.
So transfer of it, let's do the highlight here. Intestate is on page 373. Intestate is without having left a will. Testate means you prepared a will. This is at the bottom of the page.
Mm-hmm.
Probate or administration is the legal process where the court determines who inherits the property of that deceased person and what the assets are after all debts have been paid. Everybody got that?
Mhm.
Yeah.
I'm good.
Remember, this is the slide we already went through in that previous chapter 5. I had all these death terms there. So, by the way, if you have not, here's a chance to get these links. Let me also copy them over into our class links Word document. How about that?
Oh, okay.
You copy them over there. Where's that class links Word document? Boom. Okay. All right, transfer of property by will. Let's highlight this stuff. The last will and testament is the instrument made by an owner to voluntarily convey title to the owner's property after their death. And the
Okay.
will takes effect after the descendant, after the death of the descendant. But until that time, property is covered by the last will and testament conveyed by the owner. A party who makes a will is known as a testator. That's a man. Testatrix is a female. The gift of real property by will is known as devise. That's interesting here. In New Jersey, children can be disinherited, but a surviving spouse is entitled to at least 1/3 of the estate. And the determination of the augmented estate is a complex calculation. In a case where a will doesn't provide the minimum statutory inheritance, if your spouse tried writing you out of the will, or they left you less than what the law requires them to leave you, the surviving spouse can say, nah, I don't think so. I'm going to exercise my right of election. This is a right that's reserved only for a surviving spouse to get the minimum that the state requires your spouse to have left you of their estate. So if you're married and your spouse dies, can they write you out of the will or leave you less? Sure, they can. But if they do that, you don't have to agree to it. You could say no, because the state law requires that you have to leave me at least 1/3 of everything. So instead of just taking nothing that you left me, I'm going to exercise my right of election and get 1/3 of it all.
Mm-hmm.
That's what the right of election is. You're not going to get that on exams. I just got this highlighted to explain it to you guys. Okay, so you don't need to study the right of election. Now, a will differs from a deed in that a deed conveys the present interest in the real estate while you're alive. A will conveys no interest in the property until after you die. Highlight, to be valid, a deed must be delivered during the lifetime of the grantor. Remember, because when does the ownership transfer? Upon delivery and acceptance of the deed.
Mm-hmm.
Now, up until you die, can you sell your property?
Yeah.
Sure you can.
Yeah.
So make sure you update your wills. If you have a will and you sell something that you named that you left to somebody in a will, say that you said that you're going to leave your house to somebody upon your death in a will, but while you were still alive, you sold that house. Make sure you update your will. Let it say that you sold it, so therefore they don't get it. If you sell the property while you're alive, but you still never updated your will where you were going to leave it to somebody, are they going to get anything? No, because you sold it. So make sure you update your wills too, periodically. Remembering legal terminology. This is in chapter 7. There's going to be something like this. We don't have to go there right now. In chapter 7, we'll highlight it. But remember, I told you there's a root word, and with legal terminology, words that end in OR is whatever the meaning of the root word is, but that's the person who's giving whatever the root word is. And words that end in EE, that's the person who's receiving it. Like devise is when you leave a property to somebody in a will. So the devisor is the one who's leaving you the property in their will, and the devisee is the one who's going to receive it. Grant, anytime we sell a property or give away property, we're granting the ownership to someone else. So the grantor is the one who's selling or giving the property, and the grantee is the one who's receiving it or buying it. Okay, same thing with a lease. The lease is the document where an owner intentionally conveys their property and all their rights to that property to a tenant for a limited period of time as defined in the lease. So therefore, who gives the lease? The lessor. That's the
Lessor.
landlord. And the tenant is called the lessee. See, doesn't this make this a lot easier to be able to identify who the characters are and understand these terms?
Yep.
This is going to be the only exception to that because it's the opposite of what most people think. When I ask people what a mortgage is, most people say it's a loan. It is not. A mortgage is a promise to pay. And banks don't make promises, they make loans. See, there's a mortgage and there's a loan. Put those words together, it's a mortgage loan. A mortgage is a promise to pay. If you are the borrower and you make a promise to the bank that I will pay you back according to the terms in the note if you lend me the money to buy the house. And if I fail to pay you back, you can foreclose on me, sell that property at auction, and use the proceeds to pay off the debt. That's the promise to pay that a borrower is making when you have a mortgage loan. There's two parts to the mortgage there. Okay, so the mortgagor is the borrower. They're the one that's making the promise. They're giving the promise to the bank, to the lender. In exchange, the lender is giving the borrower, the mortgagor, a loan. But that's a whole, you need to remember that whole process. So here, just remember it this way. It's probably the person, the opposite person that you're thinking of. It's backwards. Or remember this way, a little rhyme. The mortgagor is the borrower. Who is the mortgagor? The borrower. It's easier to remember. You just sing it out. It rhymes. The mortgagor is the borrower. And then you don't have to think about it. Look, what I tell you all the time. Keep it simple, stupid. I like the
Yes.
concept, Don't make me think. This is thinking too much. I got to remember that the mortgage is a promise to pay, and banks don't make promises. They make loans. The mortgagor is the borrower. Let's cut to the chase. That makes it a lot easier, right? You're probably not going to get a question on exams that says, who is the mortgagor? But these terms, mortgagor, mortgagee, are going to be used in some long-winded question. And if you can't identify who these players are right away, you're not going to understand the question or what it's asking of you. So this makes it a lot easier to remember and understand and grasp these questions. The mortgagor is the borrower, right? I hope my annoying voice gets stuck in your head. Who is the mortgagor?
I'm trying to write it the way you sing it.
Who is the mortgagor?
The borrower.
The borrower. Now, there's no rhyme of that for the mortgagee. That's the other guy. The mortgagee is the lender. But the mortgagor is the borrower, so therefore the mortgagee is the lender. All right.
I'm writing in my notes, sing the song.
Sing the song. The mortgagor is the borrower.
Oh, God. Can't make this up, huh?
All right.
Love
The
it,
legal
love it.
requirements for making a will, the last will and testament. Oh man, we're out of time.
What
So
time is it?
we're gonna pick it up here on
Okay.
Monday. Wow, how time flew. So let me